The state of Florida is one of the few states that actually televises or live streams their oral arguments at the Florida Supreme Court. And today we're going to look at the oral argument in the murder case of Markeith Loyd, who is the individual who shot an Orlando policewoman to death several years ago. So let's jump into that right now. In 2017, Markeith Loyd killed Lieutenant Debra Clayton of the Orlando Police Department in a gun battle out in front of a Walmart in Orlando. He then went on the lam and he was eventually caught by the Orlando Police Department.
Most wanted man in Florida is waking up in a hospital this morning. Police captured Markeith Loyd Tuesday night in Orlando. The chief says he resisted arrest and he's now being treated for minor injuries before they haul him off to jail.
That's what this particular case is about. I was a new lawyer and got my first job as a clerk at the Missouri Supreme Court. I imagined that I would get to see great lawyers give impassioned oral arguments in front of the state's highest court. Well, reality was a bit of a disappointment. The fact of the matter is, most of the lawyers who get up there are nervous. Most of them have a very limited amount of time. The way it works at oral argument is you'll have a block of time. In civil cases, it's usually no more than 15 minutes. And how that time works is they will give you a series of lights. There'll be a green light until you have about 2 minutes to go. And then at the 2-minute mark, you get a yellow light. You know you have 2 minutes to finish up. And then you get a red light telling you, hey, sit down. So it is a time-sensitive business that you're in when you're up doing an oral argument. In death penalty cases, it can be 20, 30 minutes sometimes, but not a whole lot more than that. And you've got a 100 to a 115 page brief that you have to distill down to the most important parts to talk with the court about. And sometimes it doesn't matter what you want to talk about, it matters what the court wants to talk about. And you have to be prepared for every issue that's in your case and in your brief. As a result of that, you tend to get a little nervous and you tend to talk faster. And I think you'll see as you watch Markeith Loyd's lawyer here, you'll realize what kind of stress this lady is under, given the fact that she's trying to at least keep him off of death row. She'd really like to get his conviction overturned, but that seems unlikely. So she really wants to keep him off of death row. So, with that understanding, let's take a look at a little bit of this oral argument, and I'll offer my comments along the way.
The jury was out for 5 hours in guilt phase and 5 hours in penalty phase. There were no easy decisions for them in this case, and that's why the closing argument problems in both phases and the jury instruction problems in both phases matter. There were 3 objections to the penalty phase closing that have carried forth into the appeal. The point is preserved as to all 3 comments. 2 of our objections were overruled. The 3rd was sustained, but counsel followed up with a motion for curative instruction, which was denied. If those rulings are erroneous, those rulings overruling our objections and denying the curative, if they are erroneous, then the state's burden in this appeal is, of course, to show beyond a reasonable doubt that the verdict in penalty phase was unaffected by the objected to argument. The first argument we objected to in closing was you try your best to reach a unanimous verdict. Now, counsel and I have disagreed on exactly what was said. It was a long sentence. At the beginning of the sentence, state attorney says you have an obligation to give meaningful consideration to everything, and not only that, but to try your best to reach a unanimous verdict. It's my position that they may well have heard you have an obligation to reach a unanimous verdict. At the very least, they heard it is the prosecutor's personal preference that they try to reach a unanimous verdict.
Did you catch what she was doing there? She essentially characterized a sentence as being basically that he was asking them or telling the jury that they had an obligation to reach a unanimous verdict. But if you paid attention, what he said is not that. What he said is you have an obligation to give full consideration, and not only that, to try your best to reach a unanimous verdict. What she is saying is that equated to him saying you have an obligation to reach a unanimous verdict, which I don't think is what the sentence actually says. But you have to understand that for these people who do public defender work, particularly appellate defender work, they have a client that is generally despised by the population. They committed an awful crime. Debra Clayton was an officer in the Orlando Police Department who was killed by Markeith Loyd. And her job as the public defender is to try to save his life and also, if at all possible, to get him acquitted, even though that seems pretty unlikely given the fact that there were body cams and that sort of thing. But at the end of the day, they tend to grasp at straws. And I think this argument is so attenuated that it really doesn't have much of a chance. But I give her great credit for thinking outside the box and trying her best to get an argument in front of the court that might give her some traction.
This court held that, well, he referred to an existing life sentence, which is not a statutory aggravator, but it was really just an aspect of his analysis that the statutory aggravator was weighty. Here, the connection is not as clear that a prior felony, of course, can take place without 5 life sentences. Our position is that the state did rely impermissibly.
Let me ask you, did the jury know independently of this comment that the life sentences existed, that he was under life sentence?
Oh, yes.
They knew that?
Yes.
Okay.
The statement and the state's statement is true, but that's of course not the end of the inquiry. They can't come in and say, well, we review these cases very carefully.
If they knew it already, the impact of it, it's like, well, they're telling them something they already know.
We asked for a curative which consisted of disregard, and we think we were entitled to that. Disregard any effort to denigrate a life sentence. But
It's hard to see the harm if it's something they already know.
Well,
tell me why I'm wrong.
Well, as to the entire point,
because you've got to presume that they can add 2 plus 2. Okay, that
they can.
It's kind of the acknowledgement of something that is obvious.
But there's got to be some kind of aggravation for the state to be arguing. They got no business arguing non-statutory aggravators. They can argue the mitigation is weak. They can argue the statutory aggravation is strong. They're pretty much limited to that. And they came in and said, "Is her death nothing?"
Well, I'm talking about the harm. I'm talking about how you can actually think this is going to have any impact on the way the jury is processing all this.
I think the point as a whole, the 3 arguments taken as a whole, created significant harm, and it is. And I also believe that the briefs establish that it's the state's burden to establish no harm.
I understand the state has that burden.
So here's this nice lady trying to get her argument out in front of a judge, and the judge asked her a question that I don't really think she had prepared for, which is, if they already knew this information, what harm was it? And she admitted, yeah, they already knew the information. So the fact that the state mentions it in the closing argument, information that's already in the record, it's already been established, it's really difficult to see what the harm is in terms of the conviction. More importantly, did you notice how she was able to sort of get back on point and still make a good argument? She's done a lot of these, and it's apparent that, her initial approach having failed, she resorted to, well, it's the state's burden to show that it wasn't harmful. And the judge says, yes, I recognize that. But obviously, you have to keep in mind, the judge has read not only her brief, he's read the state's brief, and so he knows what the facts are, he knows what the arguments are, and now he has to decide in this oral argument where she's going with this and whether he's going to grant relief or whether he or his peers are going to grant relief. And so this is one of those situations where a much slower paced and clearer articulation of what the argument is would have probably done her more good than this very rushed and stammering kind of argument that she's doing. But again, she has a man's life in her hands, so I understand it. I understand what she's doing and why she's doing it. I would probably be just as nervous if I was up there.
Oh, I don't believe there is a standard of proof. I believe that in the absence of any language placing one on the defense, there isn't one in sentencing. The U.S. Supreme
You
Court
don't think that's implicit in that?
not necessarily in this context, very much so in the trial context, but not so much in penalty phase, because the state shows the circumstances of the offense. We show the defendant's background and diagnoses. A lot of mitigation is going to come up during the defense case, but the weakness in the aggravation is itself mitigating. Mitigating, according to the U.S. Supreme Court, is a super broad concept which consists of anything that might reasonably make a juror.
But it's got to be
inclined.
established.
It's got to be established. We have no objection to the old language.
It can't just be asserted.
Correct.
So if once you concede that it's got to be established, which obviously you have to concede, you've got to have some standard for determining whether it's established. It just seems to me, and unless it's just totally arbitrary.
It's the statutory language, I think, is found to exist. So isn't preponderance the lowest standard of proof that the law would recognize? So
Yes, it is.
So found, so it's implicit.
Yes, it is. But it's our position that much mitigation arises from the inconsistencies and weaknesses in the purported aggravation. And that we especially object to this language in the current cases because the language has morphed from if you find they've been reasonably established to it is the defendant's burden. I am very worried that this language is going to lead jurors to think, well, we didn't believe anything out of their mouths. We hate them by now. They didn't prove anything believable. It could happen. It is, and if they're confronted with language saying it is the defendant's burden to prove that one or more mitigating circumstances exist, they may say, well, the burden wasn't met, so death. I'm very much afraid that's the case.
And there you have it. She kind of gave away the game. She wants to save this person's life, but she also wants to change the law as it relates to getting this mitigation evidence in front of the jury in such a way as to lower the burden on the defendant because everybody hates the defendant. Well, I think there is some truth to the fact that the defendant has a very high burden in cases where there's been a murder or particularly in this case where a law enforcement officer has been slain. It's a tough burden, but all of the presumptions go in favor of the defendant anyway, and the state has the burden in every other aspect. They have the burden to prove the aggravating circumstances, and the defendant only has to prove that there's facts that support mitigation. And although her analysis is pretty clear, if you make it too hard for us to prove, then they're just going to say, well, he's a defendant and I don't believe anything anyway, and that creates a burden for the defendant. But I don't look, based on the argument from the judges back to the lawyer, I don't really look for the Florida Supreme Court to change that. We could go through the rest of this oral argument and we would be here all night. Let me just say, I think the lady did as good a job as she could have done with the client that she had. It was a very tough case for her, and I think she did a workmanlike job in oral argument. If you want, you can download the oral arguments from the Florida Supreme Court here on YouTube and view the whole thing yourself. It is a very good education in what goes on in the appellate courts in your state, as well as, obviously, an example of what happens in Florida. So thank you very much for watching. I appreciate all of you. I had the opportunity today while I was down at the beach to help a couple get a picture of themselves against the sunset down there. Always makes me feel good when I can help people take pictures and enshrine memories for them. So I just wanted to share that with you. I'm always telling you, try to go out of your way and do something nice for somebody. I want you to know I subscribe to the same philosophy, and whenever I can, I do. So thank you very much for watching. Have a marvelous day, and we will catch you down here at the beach next time. And hopefully at the beach instead of in this office. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.